level of pervasiveness that this is kind of allowed to continue in this country and elsewhere too. It's a worldwide problem. Welcome to another episode of A Little Privacy, Please. I'm Jason Kravitz, and with me, as always, is my colleague, and I'm proud to say, effective February 1st, my partner, Jenny Holmes. Congratulations, Jenny.
Yeah.
This is her first ALPP episode as a soon-to-be partner. Together, we lead Nixon Peabody's cybersecurity and privacy practice. We have Danielle Citron, who's a professor of law at the University of Virginia Law School. And in addition to being one of the country's preeminent legal scholars on privacy issues, she's also the author of A Fight for Privacy, Protecting Dignity, Identity, and Love in the Digital Age. I actually love this book. It's a really comprehensive and sober discussion about how sort of antiquated and in many ways inadequate our current legal system is for protecting privacy rights. It's full of eye-popping examples of privacy violations and things that really feel like they should be illegal, and in some cases should be criminal, and people should be going to jail for doing these things. But if you read this book, you'll realize that in many of those cases, they are not illegal, and it's very frustrating. So this book really is kind of a privacy masterpiece, and I encourage everyone out there to read it. So welcome, Professor Citron. We're delighted to have you.
Thank you so much for a kind introduction of the book. I so appreciate it, and for reading it.
No, our pleasure. And Jenny, I'm a little bit starstruck, so why don't you go ahead and toss out the first question?
I will, but I'd be remiss if I didn't start off with a go who's. But so, Professor, a central concept in your book is that of intimate privacy. Can you explain what that is and why that is so important?
So just to define it and then explain sort of the role that it plays. So intimate privacy refers to the privacy that is afforded in the way that we manage the boundaries around both information and access to our bodies, our health, our innermost thoughts, which we document all day long, searching, browsing, right, sharing, texting, communicating, our sexual orientation, gender, sexual activities, and our close relationships. And it's descriptive, but it's also normative. That is, in carving out these kinds of boundaries around our intimate lives, they're so central to who we are, to figuring out who we are, to enjoying both self-respect, which is so at the core of Warren and Brandeis's vision of how we see ourselves often through others' eyes, right? How we enjoy human dignity, and the ability for us to build relationships, right? We know, because this is our practice, and it's always lovely talking to real serious privacy professionals, as you both are, that we know privacy is a we, it's not a me. And we need intimate privacy to forge those, close relationships, not just love relationships, but for all of us to feel safe, to share in confidence our bodies, our minds, our thoughts, our vulnerable selves, our silly selves, right? It is through intimate privacy and gathering people in that we can really flourish, right? Both in ourselves and as communities and for our democracy.
Professor Citron, in your book, you argue for changes to Section 230 of the Communications Decency Act. A lot of people, I think, agree with you that reform is needed. They may disagree about the particulars. So what is it that you argue should be changed about the law? And what impact do you think that those changes will actually have on the level of protection for privacy rights?
So I imagine for your listeners, they know what Section 230 is. I feel like it's the thing you walk in a party and no one has any idea what you're talking about. But of course, it's the law that provides and affords an immunity to online service providers for user-generated content, with some few exceptions. And that's led to, we know the biggest tech companies and platforms, they are under no legal obligation to take down intimate privacy violations, though some do after a lot of bad PR and some work that we've done at the Cyber Civil Rights Initiative. But there are 9,500 sites whose raison d'etre is intimate image abuse. And they get to collect information, earn advertising fees, and, right, often they have subscriptions, but they do not have to internalize any of the costs that they externalize. And why are they often located in the US? It's because of Section 230, right? Because they get that free pass from criminal and civil liability. Not federal criminal law, but, but for the most part, there are no federal criminal actions against these website operators, and only in a kind of very rare case where we're seeing extortion. So I've been calling for Section 230 reform for a really long time. Was a really unpopular thing to utter in 2008. I was like, everyone thought I wanted to ruin the internet. But I suggest, and I have been working even since the book's been published, on clarifying precisely the reform that I'd like to see. And there's a bill coming out by Representative Jake Auchincloss, which follows the model that I'm going to tell you about. So it's not quite out yet, but there is a bill that's going to be released pretty soon that follows along this direction, which is, we know the costs to speech and to life opportunities that intimate privacy violations and cyber stalking inflict, right? We have studies showing that when your nude photo is posted online, or a deep fake sex video of you is posted online, it appears in a search of your name, or people can access it. It's impossible to get a job, to keep a job, and frankly, to feel safe. And that's also true of cyber stalking, right? That is the persistent targeting of someone with online abuse that's really designed to silence them. And so my reform efforts are aimed at a problem that we know is really costly, that it's most often costly to women and vulnerable people, minorities, and that we got receipts. Like at the beginning of my work, we didn't have that empirical work, and now we do. And so what I have like a two-tiered approach, which is, we should carve out bad Samaritans, right? This whole Section 230, the subtitle of the statute that we're taught, part of Section 230 is Good Samaritan blocking and filtering of offensive content, right? Entities that purposefully or deliberately solicit, encourage, or keep up intimate privacy violations, cyber stalking content, and deepfake sex imagery, they should not enjoy the immunity. It doesn't mean they can be sued and automatically are liable, not at all, right? I'm not calling for strict liability, but the bad Samaritan carve out would mean if you're basically in a business of pain, right? If your raison d'etre is intimate privacy violations and encouraging and earning money, if your business model is online abuse, cyber stalking, or intimate privacy violations, you certainly don't enjoy or deserve the immunity that was designed to encourage self-monitoring, right? That's what Representative Cox and Wyden were after. Okay, so that's the first part. And the second is, well, what about I've been working with, or did used to work with Twitter, right? But in working with companies like Facebook, TikTok, as I do, right? In working with these big companies, so often, it's not that their practices aren't perfect, right? They're not all bad Samaritans. There are a lot of platforms that some are pretty good, but some are hit or miss, right? And so what this bill would do is to say, you can enjoy the immunity from liability for intimate privacy violations and cyber stalking, as well as deepfake sexual imagery, like digital forgeries, if you take reasonable steps. Now, that's the proposal in the book. But what I've done in my most recent work is prescribe what those are, right? What are the 6 reasonable steps that in working with companies for 12 years that I've seen evolve? And because I got great feedback from colleagues, whether at EFF or Ken Abraham down the hallway from me, to put in a statute, you've got to take reasonable steps. And if you do, you can enjoy this legal shield. The critique was, it's so unclear, you're going to have over and under correction. And so because having worked with companies and knowing what good practices look like, right, it's often providing those procedural, the ability for people to contact you, to complain, to have information that's been adjudicated as intimate privacy violations or defamation, or right, that have been adjudicated as cyber stalking, that you got to take it down. And so the statute that we're going to see rolled out soon, and the statute I talked a bit about in a new article called How to Fix Section 230, it has those 6 steps built into the project, right? So that it's in the statute versus having to have courts in the common law slowly develop what that is, which creates uncertainty. And I imagine that your clients would not love uncertainty, right? And nor do you love uncertainty. And so taking that wisdom from Ken Abraham, I sort of we put very specifically the 6 steps into into the statute. But that's the proposal, right? It's quite narrow. It only applies to intimate privacy violations and cyber stalking content. It would carve out the worst of the worst, bad Samaritans in the business of intimate privacy violations and cyber stalking. And it would create basically a duty of care that comprised of 6 things for the hosting of intimate privacy violations and cyber stalking content. And if you do and you take those reasonable steps, then you're going to enjoy the legal shield. But I think the problem, because of the harm that is being externalized and not internalized, because we're losing voices from the internet, we're losing voices from our often online engagement and communities, that we've got to do something, right? What do they say? Like, the internet will break, Danielle, if we do anything about Section 230. And that is just honestly now absurd. These companies are fully mature. Even the smallest of operators can create incredible amount of harm. So I don't care how small you are. If your business is abuse, you shouldn't be in the business. You could be, but you should face liability.
Well, I know as a practitioner, I appreciate having guidelines of what those reasonable steps are. And sticking along the lines of, legal protections, why do you think that Europe is so far ahead of the US right now on this topic?
Yeah, right. It's true that they're kind of working through in the online safety bill, creating duties of care for platforms. And it's, I think, in the spirit of understanding privacy as a human right, kind of seeing that privacy and speech can be balanced, that in fact privacy is essential for free expression. I think that's perhaps why in their online safety bill they have pressed forward in a more aggressive way. Their policies around non-consensual intimate imagery aren't terrific. There have been some really interesting proposals, but they're as haphazard as we are in terms of their sort of criminal and civil penalties around individual perpetrators. So it's interesting. Like, yes, they are definitely a step ahead of us with the online safety bill. And we'll see what happens, right? Whether that, where it goes, and if indeed it becomes, the prevailing norms. But so in a way, I think it has to do with the approach in thinking about privacy, both familial privacy, but of course, data privacy, those two pieces as a human right.
So, Professor Citron, I'm curious, when you think about law professors and publishing their works, most of the time we think about sort of dense law reviews that are just chock full of legal citations and footnotes, and they're not usually page turners. Why did you decide to write a book instead of just focusing on something you would view as more traditional academic work?
So preceding this book is like 6 law review articles. So I can't say I don't write those things, right? Like, that is, I wrote an article called Sexual Privacy in the Yale Law Journal, that came out in 2019, and a piece with Bobby Chesney about deepfakes in 2019 in Cal Law Review, which started for me articulating as best I could why intimate privacy was special, why it deserves special protection, and why it should be understood as a civil right. And then I wrote a bunch of law review pieces, right, to talk about companies and governments and their obligations. But, your question was really like, why write a book, right? Why? Because our coin of the realm is, of course, law review articles. And, I wanted to make sure that the conversation about intimate privacy was a conversation we're having with everybody. Because, I have 2 kids who are 22 and 25, right? They're now in law school. But as they grew up, I'd always get drawn into talking to schools wherever we lived in Baltimore, about intimate privacy and intimate privacy violations. And the people we need to listen are often parents and teachers. And the parents who say, my Johnny would never do that. My Janie would never do that. When in fact they're doing and violating intimate privacy at a scale that's terrible, right? That I think we need to all see this project as all of ours, right? That not just to speak to policymakers, which I do, and law enforcers and state attorney generals and the FTC, but that the conversation is one that's broader. When I got the MacArthur Fellowship in 2019, it's basically, they say, like, we're going to give you money and you do whatever you want with it. Like anything, like buy a house. And my thought was, I want to write a book. So I bought myself a year of time and didn't take a sabbatical, meaning my husband's like, really? That's what you're doing? I was like, mm-hmm. And I gave myself, I was moving between BU and UVA law, and it gave me a year to sit down and write it, which is what I did in 7 months. And it was like the gift to myself, but it was what I wanted to thank the MacArthur Fellowship for letting me do that and giving me the luxury of time. And I think it's an important way that we communicate with policymakers, with parents, with teachers, right, with law enforcers, that we use books to get people thinking about this as not somebody else's problem, or rather with resignation. So often, right, we say, oh, there's nothing we can do. And I think that's quite right. On an individual level, it's incredibly hard to think that what we do as individuals can protect us when our data is in thousands upon thousands of databases and being sold hand over fist. But I do think we need laws that help build in structural protections. And part of that is getting, so Representative Auchincloss, you never have the principal call you, but he called me and he was like, I love your how to fix Section 230 in your book. Let's write a law. I was like, really? So it's pretty neat, right, to see the way the work is received, and then in the hopes that it might move the needle. And at the Cyber Civil Rights Initiative, where I'm the vice president, we have made some changes in the last, I want to say since 2014. We went from 3 states that criminalized the disclosure of non-consensual intimate imagery. There are now 48, DC, Guam, and Puerto Rico. So they're not perfect. We need to fix these laws. They're misdemeanors. They're not enforced. We got work to do. But I think getting lawmakers to the table, and we've been, Marianne Franks and I, my partner in this, she's our president. We've been working with the White House Gender Policy Council to meet with state lawmakers to think about next steps. I can't make Congress do anything. We have a bill to criminalize non-consensual pornography in House and Senate. Bipartisan support hasn't been passed in 7 years, right? But I think we can move the needle with state lawmakers who are really motivated, and it's totally bipartisan. So in a way, that's why a book, right? Because it can speak to everybody.
That's great. And, I know Jason and I want to take this opportunity as well to ask you, if somebody's been victimized by a violation of their intimate privacy, or if someone is interested in helping those victims, are there some organizations you can recommend?
So in the United States, the Cyber Civil Rights Initiative was really the first. We're now a decade old. And we have a hotline. We have sort of recommendations of the state laws. I wish and we have a partner organization, the Cyber Civil Rights Legal Project, which is K&L Gates has like a pro bono practice that welcomes people who've been victimized by non-consensual intimate imagery to get in touch with them. And I wish there were more. You know what I'm saying? Like, I feel like we're like a little organization that we run on like steam, right? No money, but I wish there were more resources to point to people, because some of the biggest battle often is when folks go to law enforcement, even if there are laws on the books, harassment, stalking, threat laws, intimate privacy laws, specifically addressing sexual privacy invasions. Law enforcement is beset by social attitudes that just says too bad, so sad. And if you have an advocate, you may go further, right? We don't yet have a deep pocket. So there's a few amazing lawyers like Carrie Goldberg, who practices in Brooklyn, whose specialty is intimate privacy violations. But she's got to make a living. Everything can't be pro bono. So I'd love to encourage law firms to work with us and do more work and more pro bono work, because there's like a huge legal vacuum, and often it's under enforcement of the law, besides fixing the law.
Professor Citron, we got a couple of other questions. You mentioned your move from Boston University Law School, which is my alma mater, to UVA, which is where Jenny got her undergraduate degree. And I have a hard time wrapping my head around why someone would move from Boston to Charlottesville, but I'm wondering if you could give us a non-evasive, non-legal answer as to whether you prefer Boston or Charlottesville.
Oh my, I'm so not a cold person. So it will not shock you that living in Boston, having lived in Baltimore for basically 20 years, I was at University of Maryland for 17 years. I got used to the like really chill weather, very temperate weather. And we moved to Boston and I was like, wow, this was a mistake.
Well, since we now have determined that Charlottesville is superior, what is your Bodo's bagel order?
Oh, hey, the salad. I'm like the
Oh.
Caesar salad with chicken. So Jenny, if you need a shipment, you let me know.
Well, that's going to do it for this episode of A Little Privacy, Please. Professor Citron, thank you so much for joining us and letting me take a walk back down the corner in the downtown mall. We'll see you next time.
In your book, Professor Citron, you dropped this very subtle hint that you enjoy a glass of whiskey on occasion. So what's your whiskey of choice?
I just know what's in my cabinet.